I saw a news story yesterday about Uvalde, Texas, finally settling with the families of the people who were brutalized and murdered in 2022 at Robb Elementary School. And I've had a lot of time to reflect on it. I've never really talked about this, but we're going to talk about it today. So let's get into it. What's up, you guys? Welcome back to Southern Draw Law. My name is James White, criminal defense attorney, former prosecutor, former police officer. Today, we're going to talk about a straight line, a line that starts in 1968 with a Supreme Court case called Terry versus Ohio and ends in a blood-soaked classroom at Robb Elementary School in Uvalde, Texas. This isn't just a video about law. It's a video about what happens when our legal system prioritizes officer safety over public safety with the most dire and foreseeable consequences imaginable. And more importantly, how the courts over decades have created a culture that allows police to be aggressive when it's easy and absent when it's conveniently less safe for them to be brave. Terry versus Ohio was supposed to be about a narrow exception. It allowed police officers to briefly stop and detain someone, potentially frisk them based on the circumstances, if the officer had reasonable articulable suspicion that criminal activity was afoot. Now, reasonable articulable suspicion is certainly a lower standard than probable cause, which is what was required up to that point. But the real legacy of Terry wasn't in what it permitted, it was what it introduced. And that was that the idea that an officer's feelings of danger could justify a constitutional intrusion that didn't exist prior. That doctrine of officer safety slowly bled into nearly every corner of Fourth Amendment jurisprudence. Cases like Pennsylvania versus Mimms and Maryland versus Wilson took Terry's logic and stretched it into traffic stops, saying police could then order drivers and passengers out of a vehicle as a precaution for officer safety. And from there, the courts just kept drifting. They let cops search or pull guns on people or have a heightened sense of alert based on furtive movements, which never really has a concrete definition. They let cops escalate based on what they perceived, not what was actually happening. The judiciary didn't just create legal rules, they created a culture of deference where the officer's comfort was more important than the civil rights of the person that they are dealing with. This is the part people miss. The problem isn't Terry itself. The problem is how the courts refuse to limit Terry's reach. They've abdicated their responsibility to draw boundaries. And what started as a detention that led to a pat down on a street corner became a constitutional blank check for police to do whatever they wanted. If they just say that they were scared or said the right things or crafted the right language, which ultimately leads to misleading police reports and a lack of accountability in law enforcement altogether. And then we get to Uvalde, where officer safety becomes officer cowardice. 19 elementary school children and 2 teachers died while nearly 400 police officers waited in the hallway. They didn't act because it was dangerous, because they believed it was a barricaded suspect, because they were waiting for gear, because someone else was supposed to go first. And all the while, they kept other people from going inside under threat of arrest. But here's the truth. Officer safety was the excuse. And it's the same excuse courts have been validating for decades. And it's not like Uvalde was the first example of officer cowardice disguised as officer safety. It happened at Parkland when Sheriff Scott Israel's cowardly deputy stood outside Marjorie Stoneman Douglas High School, too afraid to make entry. And they used the same excuses, basically, that the cops at Uvalde did. So when real threats exist, the superficial bravery attached to the badge seems to dissipate. How many videos have we seen of police being tough with people who aren't threats, dressed like they're going to war, yelling at unarmed civilians, slamming people to the ground for talking back or lightly touching their vest? But when it comes time to confront a real threat, when children are bleeding out behind a locked classroom door, they fold. That's not bravery. That's not public service. That's what happens when the system teaches cops that their safety is the priority and insists on public compliance with dire consequences in the absence thereof, under the notion that public safety is not only secondary to officer safety, but it's actually been rendered as an optional consideration, one that doesn't seem to be part of much of the calculus at all. The courts created this. They built a legal framework where fear is a defense, no matter how irrational. And we can pin it to things like objective reasonableness and what a reasonable officer would do under the same or similar circumstances. But that's just language that seems to provide a conduit for good faith exceptions and qualified immunity language. And we've created this entire complex of insulation for people who don't do what they signed up to do. And what happens is cops are immune from the consequences as long as they say the magic words, I feared for my safety, or I was afraid, or officer safety. And that mindset has infected police culture. It trains officers to see every encounter as a threat, to escalate fast and retreat even faster, to act like soldiers when facing unarmed civilians and act like civilians when faced with danger. We have a public safety crisis, and the doctrine of officer safety is a huge part of the problem. Not because we don't want police officers safe, but because we've allowed them to prioritize their safety and to believe that it matters more than the lives they swore to protect. In closing, Terry versus Ohio, or the justices who made that decision, didn't directly kill those children in Uvalde, but their decision, their opinion opened the door to a culture where we are forced to accept that police can be aggressive when it's easy and convenient, and invisible when it's difficult. And until we demand more from our courts, our lawmakers, and more importantly, our officers and their leadership, this will keep happening, because public safety cannot survive in a system where officer safety is the only thing that becomes part of the calculus. I mean, I guess I was confused this whole time when I became a police officer, and every single day that I went to work as a police officer. And I was not a perfect police officer by any means. I made tons of mistakes. But every day that I went to work as a police officer, I understood that it might be the last time I left and returned to my house. I didn't think that was only where someone would get the drop on me in a situation that I never saw coming. No, I believed there was always a possibility that I would have to make a decision to sacrifice my life for someone else. And I was ready to do that when and if necessary. I genuinely believe that I would have done better on the other side of that door. I can think of no more virtuous way to leave this earth than to substitute my life for those of elementary school children. So if you haven't figured it out yet, I'm having a really hard time these days finding sympathy or common ground with the heroes hiding behind the blue line that seems to only function as a border wall that separates us from them. And that's why I have referred to our system over and over and over again as more of a just us system than a justice system. I don't know where we go from Uvalde. I don't know what happens next, but I don't have any confidence that it's going to be good. Anyway, that's all for this one, guys. I just thought it would be appropriate to go ahead and talk about it on the day that I learned about this sort of final chapter with the actual town or city of Uvalde. Again, they have more avenues of redress in the federal courts and the Texas Department of Public Safety and other things that are going on with the families of the victims. And I'll try to follow up on any information that comes out as a result of those matters that are still being litigated. I'd like to invite you to head over to the Substack community and join us. It's absolutely free to join. I'll always make the posts that I put out free to anyone who wants to read them. There are opportunities on paid tier levels if you just want to support financially. If you don't want to follow me over to Substack or follow me on a separate platform, but you'd still like to support the Southern Draw Law channel monetarily, I'll post my Venmo and PayPal links both here on the screen as well as in the description. Please remember to like and subscribe and leave a comment on the video. Check out some of the other videos on the channel and leave a comment on there as well. Until I see you again, take care. Always film your interactions with the police and keep your evidence to yourself.